Welcome to our Shorthand Lab Prayagraj. Legal dictation at the speed of 110 to 120 words per minute. 10 seconds remaining. Start. The learned counsel for the appellant submitted that the appellant was not given any so-cause notice after forfeiture of his personal bond, and as such imposition of penalty was not proper. Stop. It was further submitted that the learned lower court has committed gross error of law in releasing the appellant on bail on his depositing cash amount of rupees 50,000 as penalty. Stop. Para. When the appellant committed breach in appearing in the court concerned, the personal bond submitted by him was liable to be forfeited, but imposition of penalty and its recovery without giving any opportunity of showing cause to the appellant was not proper. Stop. The law in this regard is well settled. Stop. As and when any bond filed for appearance is forfeited, it is incumbent on the court forfeiting the bond to give a notice to the person whose bond has been forfeited, calling upon him either to pay penalty or to show cause as to why it should not be paid. Stop. If he pays the penalty in pursuance of the notice, the matter ends. Stop. If he does not pay the penalty and offers some explanations showing reasonable causes of his non-appearance, the court has to consider the causes and pass a reasoned order thereon. Stop. If the cause shown is not sufficient, the amount of the penalty should be determined by the court, and if the penalty so determined remains unpaid, the court has power to make recovery of the penalty as fine. Stop. If the person to whom the so-cause notice is served offers sufficient causes, the court has power to discharge the notice and remit the penalty. Stop. The order remitting the penalty wholly or partly must be based on reasons to be recorded by the court. Stop. The provisions of section 441 CRPC are very clear in this regard. Stop. Para. In the instant case, the learned lower court forfeited the appellant's personal bond by the impugned order itself, but instead of giving the appellant the notice as required under section 446 CRPC, either to pay the penalty or to show cause as to why it should not be paid, determined the amount of penalty to the extent of rupees 50,000 and proceeded straightway to make the recovery. Stop. In my opinion, the learned lower court has not only violated the basic requirements of section 446 CRPC but has also exceeded its jurisdiction in imposing the penalty on the appellant immediately after forfeiting the bond. Stop. Para. The learned lower court has committed another error of law in calling upon the appellant to pay the penalty of rupees 50,000 as a condition precedent for his release on bail, besides calling upon him to furnish a personal bond and two fresh sureties. Stop. The law does not empower the court to require the accused to deposit cash amount for his release on bail. Stop. The imposition of the condition for depositing rupees 50,000 as penalty for release of the appellant on bail was beyond the jurisdiction of the learned lower court. Stop. Thank you so much.